Usually, after a conviction takes place, between the conviction and the sentencing, we hardly see any time, a day, a maximum a week. But perhaps unprecedented in such criminal cases, we are seeing the Uphaar case where 59 people died in 1997. That's 18 years ago. And two people, those are the Ansal brothers, Sushil and Gopal Ansal, they were convicted. Their conviction was upheld 17 months ago, and yet the quantum of sentence is yet to be delivered. Today was the day of yet another hearing to decide that quantum of sentence, and we have over here the families of the Uphaar victims. They'll be joining us to talk about just why it is that this case has been singled out for such delays. We'll be talking to them in just a bit, but first, Siddharth Pandey tells us about the unusual circumstances in court even today, which has been typical of the entire case spread out over such a long time.
It's been 18 years since Uphaar happened, and the family members of those who died are still waiting for justice. In fact, the basic question now is deciding the quantum of punishment. That's because the judges were divided. Now, for the past 17 months, the Supreme Court has yet to hear the matter. On two occasions, one on the 21st of April and the second on the 4th of August, this matter came up before the Supreme Court, but it was adjourned because in both the cases, the counsel for the accused, for the Ansal brothers, wanted an adjournment. Today again, the Supreme Court was to have heard the matter in the morning, and once again, the Ansal's counsel, Mr. Ram Jethmalani, asked for an adjournment, saying that he was busy. The matter was listed for later this afternoon, but then again, the matter could not come up. All eyes are now on the Supreme Court, and it's expected that the court perhaps will hear this matter tomorrow and perhaps finally begin the process of bringing a closure to this case. In New Delhi, Siddharth Pandey for NDTV.
During the course of the show, we are going to hear just some of the reasons, the bizarre excuses that lawyers of the defense have presented during the course of the trial. And we just ask whether it's because, in this case, the defense comprises some very, very powerful people. Let me just introduce our panel to you. We have, of course, the families, and the families are represented by two people who've really been fighting the most, who've been the forefront of this fight, Neelam and Shekhar Krishnamurthy. We also have Mr. Sani. They've all lost their children in the Uphaar tragedy that took place 18 years ago. We have Alok Prasanna over here with us, who is a fellow with the Vidhi Center for Legal Policy, and of course joining us from Mumbai, Ujjwal Nikam, a public prosecutor who says no, it's not because people are powerful that they get away with such delays. But Neelam, Krishnamurthy, I want to just start with you and Shekhar, of course, just to ask you that some of the things that they've used. Today you went, after so many years, 17 months it's been since the conviction was upheld by Supreme Court. Now everyone usually thinks Supreme Court has upheld, now we are going to see conviction. Now we're going to see people going to jail. Gopal and Sushil Ansal, when you got that, and yet we haven't seen that. Now can you tell our viewers some of the excuses that have been used for adjournments?
First of all, for today's adjournments, I like to say we didn't expect that they would take adjournment today, because already the matter came up after 17 months, and just last week Ansal had seeked an adjournment for non-availability of the consuls. Before that, seeked another adjournment in the month of April for non-availability of the consul. And normally in Supreme Court, they do not give adjournments once the matter is on board. But what was very surprising is that the lawyer had gone and mentioned the matter on the 7th of August, and we knew nothing about it, because as per Supreme Court rules, you're supposed to inform both the parties when you're mentioning the matter. We were not informed, and yesterday also when they were circulated the letter, they only circulated the letter to CBI. We are a party in the thing, and we were not even circulated the letter.
Yeah.
So when we went to the court, we were very surprised that they wanted an adjournment. I mean, we know this is just a ploy by Ansals to ensure that they do not go behind bars. So one thing I know for sure today, that it's been actually, I have been experiencing it for over the period of years, that the law of the land is not the same for the rich and powerful and ordinary citizens. If it's an ordinary person, he cannot go up to the judges and say, I want to seek an adjournment. But when you have cases like this, when you have people like Ram Jethmalani, because he's come to the courts and seeked adjournment for Ansals. When my matter was on board between August 2010 and 2012, Mr. Jethmalani sought 8 adjournments. and one of the adjournments was sought. So his junior came and said, my senior has lost his voice, his eardrum is ruptured, he cannot appear in the court. On the same day he was arguing in Patiala House Court.
I just wanted to tell our viewers that perhaps that we asked Mr. Ram Jethmalani, who has been the Ansal's lawyer and who of course a lot of the families have been one of the most powerful, well-known lawyers that has been there. We asked Mr. Jethmalani to come on our show to talk about all that is being talked about, but they refused to. They also refused to send any representative. But Mr. Nikam perhaps is going to give us the other side of the picture. Now, you talked about the fact that once the adjournment was there because his eardrum was ruptured.
Yes.
But there have been many such less serious cases,
but what is very important to know is, but this next day when we read the papers, he was arguing in the Patiala House Court for 2G matter. So it was nothing but a pack of lies.
And did you bring it up in court? That
no, you cannot, because once it's already sought in adjournment, the matter will come after 3-4 months and then you go and tell the judges, they don't want to listen to the litigants, I'm sorry.
Mr. Nikam, would you like to respond to this? How is it that a senior counsel is able to, as Neelam Krishnamurthy is pointing out, obviously deceive the court in that way?
See, let me tell you very frankly, I don't want to comment upon any particular case as such, but basically I would like to deal the important question that whether the delay affects or whether only powerful persons can manage about the delay, and whether what will be the impact of the delay on the ongoing trial or not. That is the precise question, and I am of the candid opinion that everybody is equal before the law. Whether he is rich or poor, it won't affect much. Now, what has happened in the particular case which we are discussing, since the matter is sub judice, I don't like to say, but at sometimes the personal difficulty of the advocate is also required to be considered by the court. Otherwise, the court has to do justice, and court can do the justice only with the assistance of the court.
He is saying,
if any lawyer has some personal difficulty,
is pointing out it wasn't a difficulty. He misled the court. He was appearing in another matter, and in their matter, they just said that he had a problem with his ear. So it's not a personal difficulty. It was a question of not making time, which is unfair to all these people, all the victims.
Again, I would like to say that it will be a very debatable issue whether there was a genuine and valid reason or not. That court will require to see.
No, I understand. We can't go into
therefore, I don't want to go into that.
Okay, fine. Mr. Prasanna, you have been studying all these cases. I'm sure Neelam Krishnamurthy and Sri Murthy are going to tell us many more such instances of how it was done. But I just wanted to ask you, first of all, the unprecedented thing of the time between conviction takes place and quantum of sentencing. Is this the first case that you're hearing of?
As far as I know, this is the first that I have seen where the court has taken so much time between confirming. Let's just clarify here. We're not talking about the trial court, we're talking about the Supreme Court.
That's right. Yeah.
And this issue of two judges disagreeing on quantum of sentence, of a two-judge bench disagreeing on quantum of sentence, is to my knowledge the first that I have seen. There may be exceptional cases somewhere, but as far as I have been able to find out, I have not found a single instance where two judges have differed on the issue of quantum of sentence. Now that's a problem with the way the Supreme Court is functioning.
Mr. Nikam says that it's untrue to say that powerful lawyers and the rich employ powerful lawyers. They are able to cause such delays. Would you agree with that?
I would completely disagree with him because, and let me say, it's not just a problem of the Indian judicial system. Everywhere around the world, if you are rich and powerful, there are ways you can get around and avoid the judicial system. But in India, I think...
In recent past, we saw Salman Khan case, right?
Salman Khan case. And I mean, it's not just about India, but in India, I think the problem gets aggravated because there are no consequences of doing so. In the US and everywhere else, you may avoid it once or twice. For instance, Lalit Modi's case in the UK, he was imposed heavy costs because he tried to abuse the system there.
Very good point.
And
yeah.
but here, of course, if you abuse the system, there is very little penalty that the system imposes upon you.
So when you brought it up to the court that look, he was at 2G, did they fine him? Did they ask him for any explanation?
No, they couldn't. That's what I told you, because the matter comes after about 4 to 6 weeks, and who are litigants?
Nobody
even wants to listen to the litigants.
You told us about the fact that once they caused delays because they said there's a solar eclipse.
Yes, it happened during the trial court when the trial was going on. Ansal's lawyer came and said, Madam, today is the solar eclipse and my client is fasting, so kindly give us an adjournment. And there are instances when they come and say, oh well, I've forgotten my brief. I mean, I was called there as a witness and they refused to...
They forget their brief and that's why you have to suffer.
Yeah, I have to suffer. I mean, this is... Or they say, we are not prepared. to cross-examine the witness. It happened with me. And I was called again and again. I had to address the judge and tell, I mean, I'm the one who has to be prepared rather than the lawyers being prepared, because
Yes.
the way they were, traumatizing me by asking the kind of question they
And
put to
then
me.
perhaps the other thing that the families have been telling us about is that some of the other excuses are that there's a bar election outside, they can't be there. And perhaps the most poignant thing in all of this, whereas you are the victims' families, you are fighting against a large company which has been convicted for negligence. The answers have been convicted for negligence, so we're talking about a case, it's just that deciding whether how much they should go. The trial court actually said 1 year.
2 years. The trial court said
2 years. They've served only 5 months out of it. And perhaps the most interesting thing out of this is that while it seems what the families were telling us is that while the court is taking into account the inconvenience and the delays and the time it's taken, and perhaps in considering how much imprisonment to give the answers, they're not looking at your wastage of time.
One of the factors which they've taken by the Supreme Court is
Yes.
a prolonged trial. So I want to ask that prolonged trial is detrimental to the victims. We are not responsible for the delay. It is the accused who time and again asks for adjournments, and adjournment culture should be stopped. That's what we've been saying for the last 17 years. At a drop of a hat, adjournments are given in the interest of justice. And we went to the High Court at every stage, be it from the framing of charges or at the time of final arguments. We went to the court and got a diktat from the High Court.
The interesting thing about this entire case is when we talk about the rich and the powerful is they have Ram Jethmalani, the defense is Ram Jethmalani. The Krishnamurtis, the Upahar victims have also been lucky that they've got, first of all, they've educated themselves in the law, so they are well educated, they're fighting the thing. They also have one of the best lawyers. They have Harish Salve. So it's Harish Salve of the CBI lawyer. They have KTS Tulsi fighting for them, another top-notch lawyer. And despite that, we are seeing constant adjournments. Despite that, we see, before anyone goes to jail, we see an 18-year delay.
Before that, I want to ask a question to Mr. Nikam.
Yeah.
We've been talking about unprecedented, and he also said that there's no such case where it is taken 17 months to decide the quantum of sentence. So I want to ask him, we still don't know.